and gentlemen, welcome to this webinar organizers under BERNAS program. I have friends asking me, is this daripada Beras National? No. This is Selangor Innovation Value Chain Selangor Innovation Value Chain Workshop, which is Bengkel Rantaian Nilai Inovasi Selangor. And this it's a organized by Quiz and also Unicel together. So thank you for joining us for today's webinar. My name is Haniza Osman. I'm a lecturer at Faculty Science and Information Technology, College Universiti Islam Antarabangsa. So today's topic is intellectual property. So I would like to welcome our presenters, our speakers, the Honorable T.S. Dr. Muhammad Shahrul bin Muhammad Danuri. He is a Director of Education Center in Kuwait, and also Puan Nurul Nuha binti Datuk Haji Nawawi, and she is a Managing Director of Nurul Nuha Sdn Bhd. Okay, that means that Puan Nurul Nuha owns her own company. Okay, that is something interesting that we would like to listen to her about how she managed the intellectual property company. And last but not least, of course, to our distinguished guests, ladies and gentlemen. So, to answer to the question that we have about IP with us today, I would like to introduce you to TS Dr. Muhammad Shahrul. It's very interesting because ada TS kat depan tu. So you all can browse internet, Google and check what is TS. Doctor has got his PhD in Information Management Research based from UiTM Malaysia. And also he had his master degree in intellectual property. That is interesting. UKM, okay, and he did his bachelor degree at USM Penang and matriculation at USM Penang too. So I would like to welcome Dr. Shahrul. The floor is yours. Thank you.
Thank you so much, Madam Moderator, Madam Haniza. To all the audience, all the lecturers, students together attend the seminar today. It's not a seminar, more towards like a forum, right? So, but the way we are conducted the forum is something different. So, it's an online style. So that's why I'm preparing some slides in order to share with you guys. And the slides will be, because we have to know all the theories and the concept, right? So before the actual understanding what the IP is. So let me introduce myself. My name is Muhammad Shahrul Nizam bin Muhammad Danuri. I'm a senior lecturer in Quiz. As mentioned by the moderator just now, even though my master degree in intellectual property, but that was in 2006, right? One Nurunuha was my classmate actually. So
yes, 2006 graduated.
2006, right? So a long time ago. I'm not a practitioner, but at least Nurunuha will help me with all the latest news in the IP world. So let me brief a bit about the IP. Try to find the everybody can see the slides. Okay, good. Will be interesting if the way we communicate will be the two-way communication. So anything, if there is any question, just raise your hands or probably just on your mic and interrupt me, okay? So intellectual property. So the definition of intellectual property is actually a form of intangible asset, the creation of mind that is created becomes an exclusive right of the creator or the owner of the IP. Okay, so it's something different from the actual property in the real world. So as you know, property is a building, something like that. But this one is created by our own mind, something in what you call tacit knowledge, all the things, and it translate into explicit knowledge. So that kind of knowledge is actually the intangible asset that created by the owner or the author. Okay, the creator or the owner of the intellectual property can be more than one entity. Either it's a person or a separate legal entities such a company or something. So anyone can own IP. So IP also created by category and will be protected according to the category act. So there's a lot of category. Let me show you what is the category. Okay, so as you can see here, as a general, the property can be divided into two category. One is a copyright, and also the other one is a industry property. So copyright, something like songs or the music or the films, what else? The artistic work, something like that. So all that one is fall under copyright. Meanwhile, the industry property is something like a patent, trademarks, industrial design, geographical indication, IC layout design, something like that. So those are actually fall under industry property. Yeah? So patent is something like a draft of a piece of paper that will outline all the invention that created by the owner, by the creator. Meanwhile, trademark, I assume everyone recognize this symbol, this R symbol in the circle, right? So that one is this is a registered mark. Okay, industrial design is something like the design, any kind of designs, which is such as sofa, maybe the car or something like that. Meanwhile, GI, geographical indication. If you heard, have you ever heard about the Sabati, something related to the location of the IP itself? That one we call as a geographical indication. Okay. Integrated circuit, yeah, all the circuits. If someone from the electronic background familiar with this kind of design, and other as well, confidential information, trade secret. If you heard about Coca-Cola, KFC, those are the things that you don't know what are the recipe behind it. It's also part of the IP. Okay, right. So the popular intellectual property in education sector, I will tell you about this only these three kind of IPs. Okay, so patent, I assume everyone have heard about it. Patent, we'll talk about trademark and also copyright. So patent is closely related to the invention itself, any kind of the invention. Meanwhile, trademark, all the logos, we call symbol, brand name, such as Adidas, Nike. So those all fall under trademarks. And copyright is all the things that I said before, songs, films, and so those actually fall under copyright. So the beginning of IP protection is actually from the idea. But bear in mind, idea is not protected. Idea is not protected at all. So everybody have an idea, right? So it's not protected. So if you try to translate the idea into the something like a material, a product, or service, come out with the results. So those are actually can be protected. And those are actually the intellectual property. Yeah? So those are we call the intellectual property is here. Okay, so we can register our IP under patent, copyright, and other as well. So once you register the IP, if let's say you are just registering a patent, so you will get a protection under Malaysia Patent Act 1983. Same goes to the copyright. You will get protection under Copyright Act 1987 and other as well. Okay, that's a lot of it because just now I present the list of the IP, right? So those are actually the things that you will get once you register the IP. Okay, so intellectual property rights is a right to which creators are entitled to their works. Okay, so regardless who's are the creators, so they will get the protection, they will get the rights. So patent, they will protect the new original invention and their inventive step, because those who get the patent have to list out all the technical steps in the patent draft. People can easily copy and recreate the things from the patent draft. So that's a patent. I will explain it later. Okay. So meanwhile, trademark will protect your brands, your business, your reputation, something like that. So those are trademark. Meanwhile, copyright protect any form of work, such your song, your pictures, your videos or something like that. So those are actually the IP rights. Okay. Intellectual Property Corporation of Malaysia, MyIPO, is actually the administrative office in Malaysia who manage the IP registration in Malaysia. Okay, so it's actually a statutory body under the Ministry of Domestic Trade, Cooperative and Consumerism from March 2003. It's just a long time ago. Okay? So the main branch is actually in Bangsa, Menara UOA, but they have other branches as well in Johor Bahru, Kuantan, Penang, Malacca, Sabah, and Sarawak. So MyIPO is actually the official body that the administration the IP in Malaysia. Okay, these are the logo. I think that's all from me. Just for the introduction, what is the IP all about? So perhaps if you have any question, you may ask me later. Okay, back to Madam Moderator.
Thank you very much, TS Dr. Muhammad Shahrul. It was interesting. It's a starter. It's a starter to make sure you are in the right track, to have a frame in your mind that what we are going to discuss more about this with Puan Nurul Nuha. Okay, Puan Nurul Nuha, I would like to invite you, but let me introduce you. Puan Nurul own her own company that deal with intellectual property, which is Nurul Nuha Sendian Berhad. So it means that Puan Nurul has the hands-on experience in the industry, and that is the most important thing, that we have not got into that, means that we don't have that kind of experience. So Puan Nurul Nuha is a registered patent, trademark, industrial design agent, and also a plant variety agent of Malaysia and certified IP valuer. So the value dia jadi penilai. So her experience extend across all aspects of IP practices, from registration, prosecution, IP training, and IP advisory. Puan Nurul had graduated from UPM, and she was conferred as Bachelor in Bachelor Science Biotech with honor. She was then an academician specialized in biochemistry. She furthered her study at UKM, and it's actually, as what Dr. Shahrul said, she was his classmate. So they were classmates before, okay? And she was excellent in her studies. I was just informed that. Okay, so without further ado, please welcome our honorable guest, Puan Nurul Nuha. The floor is yours.
Assalamualaikum. Selamat pagi. Good morning, everyone. Thank you, the Secretariat, and I would like to say bersemangat, spirited this morning to all the students of UNICELS from FSTM, I believe, and also the biology. There is biology faculty, the life science faculty, if I'm not wrong, which is I am a biotechnology graduate from UPM, and also I believe FPSM from KUIS. Okay, so Alhamdulillah, thank you, Dr. Shahrul, my brother. We joined classes in 2004, and at that time I was still working, and it is a long journey to seek knowledge. It's a long journey to seek knowledge. And for those who are here today, you are on the right path, and you are actually now going into learning what IP is and how IP affects or how IP is useful in businesses. Okay, so let me share my screen. Okay, so Dr. Sharul just now have mentioned about tangible assets and also intangible assets. Tangible assets are generally those you can see and those things that you can hold. Apa yang you boleh pegang dan apa yang you boleh nampak. Okay, contohnya, for example, this building. Okay, this building is located in Bandar Baru Bangi. It is where my office is. Okay, and yes, I am a practitioner. I started my own company in 2010, and hence it is already practicing is already about 16 years. Okay, and my office is somewhere here at 27th floor. Okay, so in this photo itself, you can see many forms of tangible assets. It can be something that is static. Static meaning it doesn't move, like this building. And you can see here something that is movable. Movable meaning you can move it here and there. For example, here cars. And other than this, you can also have tangible asset in the form of cash, in the form of gold. Those are tangible asset that is valuable. Okay, valuable. In this BERNAS program, you know, the title is Rantaian Nilai. So value is actually referring to nilai. Okay? So we go into intangible asset. What the category that was shared by Dr. Muhammad Sharul just now are actually intangible assets. Intangible asset, IP, intellectual property, is actually one part of the intangible asset, because IP by itself, if it is not connected, if it is not connected with other things, it doesn't stand alone. It has to be, if you create something, you have to work on your creations. Okay, so usually who is actually the creator? The creator is actually the human capital, those who are expert in the field, those who are learned in the field, and this or those who are skilled in the field. Okay, in our term, usually we intellectual property practitioners, we refer to those who are skilled. We refer to them as persons skilled in the art. Okay, or in short, POSITA. Okay, so brothers and sisters from the faculty, the VIPs as referred by Puan Haniza, you are human capital of our country, and our country are looking for those who are talented to create, because these human capital are those who create the intellectual properties. Okay, and this intellectual properties is actually something that it's part of the intangible, and it drives the knowledge economy. Okay, we are no more in the era of in the era of where you base your income on paddy, your agriculture only. You need to include the added value on top of the natural resources that was provided to Malaysia land. Okay, we have huge natural resources, but we cannot only rely on just basic natural resources for us to trade. We have to upgrade it. We have to improve the downstream processes so that we get more and more useful product. Okay? So why I term it as useful product? Because in the last session, if I'm not wrong, that Dr. Rahmat and Mr. Robes, they have shared with all of you what is the meaning of innovation and how innovation change the way people experience lives. Okay, so when you innovations, the two key criteria of innovation is it has to be new and it has to be useful, impactful. Okay, you have to be able to differentiate between the terms invention, or in bahasa ciptaan, and innovation. Okay, invention is ciptaan, innovation is inovasi, which is directly translated to bahasa. Okay, so there are plenty of invention. There are plenty of invention. There's a lot of talented people, creating invention. Okay, so their creation fulfill the criteria of invention, but not necessarily all invention are useful. Not necessarily all invention are impactful in terms of mass adoption. Okay, some invention are not are very narrow to the scope. Some invention are used mass. For example, long time ago, we don't have air condition, but now global warming, when our country temperature is hot, and many other hot countries, they need to use to feel good at home. You need to get the ambience, so you install air conditioner. Long time ago, air conditioner is very expensive when it is first introduced. People are still skeptical on this air conditioner, but eventually there's a lot of improvement along the way from the first moment the idea spark until it is being created, until it is being improved and further improved, until now I can say one house can have at least one aircon, at least I can say, especially in city area. Okay, so okay, so why generally talented people have the tendency to create? Of course, in the previous session, Mr. Roberts might have shared with you that people are looking at problems and trying to solve it, trying to do things more better, trying to make things so that your work can be done faster. Okay, but all this IP that is created, is useful for business. Okay, in order for you in order for us to ensure that all this IP is being bring forward to the market, you have to have a business. You have to create a business. Okay, so for a startup or for a company, if let's say you have one basic invention, basic innovation that you want to bring forward to the market, you not only rely on one form of IP, you rely on multiple forms of IP, as per explained by Dr. Muhammad Sharul just now. Okay, we have copyright, trademark, design, and so on. Okay, and this IP, the intellectual property, is an asset of a company. It drives the company value. Usually, long time ago, for example, I give a hotel business. If it is a hotel business, long time ago, people will, if you look at the annual report, accounting period, if you have completed a 1 year accounting period, you look at the annual report, you look at the end, okay, what is the total asset? Building assets, cash asset. But nowadays, it's not limited to that. Okay, if you look at Microsoft, the value of Microsoft is actually driven by the intellectual property. Similarly, Tesla, similarly others. It's not so much on what how many buildings they have, or how much money they have in the bank account. Okay, so, and if you study the character of users, mass people, they always look for something new. Of course, for many of us, sometimes we used to stick to one product. However, there is a tendency to also look at something new, especially when a company or your brand, if you're a fan of one brand, you will always look for new product that is being created by such company. Okay, so the market by itself is always looking for a trendsetter. So trendsetter is always those who create, those who introduce something new to the market are actually setting a new trend. Okay. Okay, to give you a very simple example, okay, why it is okay to be creative, or why it is okay to be different, why is it okay for you to introduce something new? Okay, so if you look at this tape dispenser, it's just a very basic functional thing. Of course, long time ago, tape dispenser is protected under patent because of the technical mechanism, how you dispense the tape. Okay, and this is the very basic look. Very basic look. And now if you search for tape dispenser at Lazada, you will see this brand, this tape dispenser, and it has no brand. It is sold at $7.90 the last time I checked. Okay, but if you look at the one next to it, you will see that, oh, what is this? Okay, some people will say this is ugly. Some people will say this is nice. Okay, it looks cool. Okay, but if you look at it, the price as it has the same function, but if you look at the price as listed at Sang-In, the price is £50. It's way expensive compared to the one on its site. Okay, so this the same function product that has the same function but has different looks, but priced differently. Okay, this is for mass. This is for those who look. This is for those who want to pay for more for the looks. Okay. So this is the designer. This is a tape dispenser designed by Studio Brown. Julian Brown is the designer, and this is how it looks. It is also referred to as Hannibal because of the cool look. This product is also referred to as Hannibal. So if you see, it has elephant trunk-like arms. Where this elephant trunk-like arms, and you open it, it will open, and you can put the tape here, and then you may use it and function it as a dispenser. Okay, this kind of upgrade compared to the one that we see just now is known as small improvement, and it is combined together with element of design. So as per explained by Dr. Muhammad Syahrul just now, there is protection for technical aspect, protection for all the ideas that you have, and you translate it into technical aspect in the form of pattern. And there is also protection for the look, which is actually under design. And this is how it looks in an open position. Okay, so frankly speaking, I've been in this field for enough time to hear a lot of reference to pattern, and pattern is not all. Okay, IP is not pattern. IP is not limited also to technology. And what the aim of IP is actually to create value change. Why you want to have it protected from the first part of the idea? You want to have it protected because you want to use the IP system as a tools. Okay, the IP system inclusive of patent, design, trademark, copyrights, and also the plant variety. Those are actually elements or category that you use to as a tools in businesses. Okay, so innovative product, how you work on and you come out an innovative product. It is actually a creation of mind, as per explained by Dr. just now. It's either can be sparked by problem solving. Okay, you have problem in this field, mechanical problem. It can be medicine problem, for example, if you are a doctor, or it can be from life experience, for example, if you have parents that suffer from this disease. So you are spirited to do something. Those people are those creators, inventors are spirited to do or to create things based on all this. Either it is problem solving, either it's because you have a creative idea, or you somehow want some clever design. Okay, so all this come out to intangible asset which must be protected under intellectual property in order for you to make use of it and monetize it. Because why the patent system or the other system is actually being created is actually to protect businesses, to protect creators. When they enter into the market, they need their product to be protected so that all their investment, time investment, money investment in product development is actually accounted for, and also the invention is being used or innovation is being used and impactful to the market. Okay, so if you look at businesses, businesses also transform from traditional, and there is now non-traditional business. Okay, why such thing happened is because it was driven by needs for change. Okay, so traditional business, if you see, maybe we have one shop, we offer for sale from the shop, but nowadays non-traditionally we have e-commerce. Okay, if long time ago we have hotel, now non-traditionally we have Airbnb, for example. Okay, still the Airbnb now is facing challenges. I can say it is a challenges because of the COVID-19. Okay, it faced challenges because of the COVID-19. At one time, its company value has rose so much, but eventually when the COVID-19 came, nobody goes for holiday, nobody rent rooms. So those are challenges. And businesses, usually what businesses do, you adapt and change your direction. You steer your business to where it is helping the product and helping the business sustain. Okay, but having said that, not all business survive. Okay, so that's why coming back to create why you innovate, problem solving and all that. So there are things that you can take steps in order for you to see and how to steer your businesses so that it stays relevant in the test of time. Okay, I give you one historical example where this business has been has moved in complete cycle. Okay, where this person create, where this person monetize and create business and monetize, and where it enforce, and where the business is actually being transacted. The whole business and together with the IP is being transacted. Because IP, when you create, it is similar to the tangible just now. You can transact it. Okay, it is a separate element where you can actually trade it. Okay, so this Betty Nesmith Graham, I'm not sure many of you, I believe many of you did not know her, but this is just for sake of example. She created the liquid paper long time ago. Her background is just an artist, and because of war, similarly, we now gone through COVID-19. So at that time, Betty, because of war, she can't cari makan, she can't work, so she has to change her career, and she become a, what do you think she became? She became a typist, because at that time there's a lot of information need to be typed and being sent being recorded and being kept and being sent at that time in 1940s. Okay. So originally she made her invention in her backyard. Originally she called it a mistake out. She continued experimenting until she arrived to a perfect combination of paints and some other chemicals. And the refined product was renamed as liquid paper in 1958, and she applied for patent and trademark. Okay, long time ago. And in 1979, the Liquid Paper Corporation was sold, the company as a whole being acquired by Gillette Corporation for USD 47.5 million with royalties. This is what Malaysian, I myself, I want people from all, I want Malaysian to be able to create this, to arrive to this, okay? From just a humble beginning, able to change the world, able to impact everyone's life, okay? And how to protect innovative product? This one, Dr. Sharul have explained just now. You have to protect it using the intellectual property rights protections, okay? And these are the example of the legal rights that is provided by the government. Okay, patent, copyright, trademarks, GI, registered design, trade secret, plant variety, and these whole are being used not solely, most often it is being used together. Okay, when you create a product, you have to have a good names in order for you to bring it to the market and all that. And there is also criteria in order for you to obtain the registration. For example, for patent, just now, as it relates to invention, as it relates to innovation, It has to fulfill certain criteria. It has to fulfill newness. It has to fulfill inventive step. It has to fulfill industrial applicability. This three criteria is actually stated in the Act, 1983 Act, Patent Act, as shared by Dr. just now. And these are legal rights. These are legal rights provided by the government to the inventor or the company that owns it. Okay. Okay. So generally, in product development, in an early stage of product development, this is actually my own depiction of how I see innovative product is being brought to the market. Okay. During the product development session, the most important legal aspect that you need to protect is actually the patent and the design. If you have the novel idea, if you have if you fulfill the inventive step and you feel that it is useful, it's best for you to protect it first rather than you share it to other people, because once you share it to the public, then there's a risk there. Okay, although there are some provisions that allow technology to be protected within a grace period, but there is always a risk. Okay, so eventually when you enter into the market, this white line is actually a position where you enter the market as I depicted. So when you enter into the market, usually once you enter the market, once the patent protection is already in place, you start to introduce the product to the market. So when you want to introduce the product to the market, you have to have a good mark to indicate the product is actually being produced or being manufactured or being owned, the technology, by you. Okay, so other than that, also you have to also have a good copyright in terms of product description. When you write on a piece of paper, the manual or the product manual or the advertisements, those are actually protected under copyrights. Okay, so along the way, when your product enter into the market, you first maybe enter into Malaysia and then you want to enter into other countries. Times flies. It goes to 5 years to 10 years. Some product, it's able to withstand test of time. It goes longer. So the period of patent, because patent protection is only 20 years, so the period of patent, the legal life become shorter and shorter. Okay, so at this point, you want your brand to be, you want people to remember you. Okay, at this point, your brand equity, when people remember you more and more, so your equity in the market is getting bigger and bigger. So even though your legal life has expired, your brand equity, your people knowing you is getting more and more people knows the product. So even though the legal life ends, still people look for your product because they rely on the brand. That is why within this period, people, businesses, they want to protect because they want to fence off others from entering into the same domain of their market. Okay, so to give you one example, everybody here makan paracetamol. Everybody here know what is paracetamol. Paracetamol or Panadol. Okay, Panadol, GSK product, GlaxoSmithKline product, is protected under patent. Okay, and the composition for controlling your mom and all that, fever. It has expired 20 years, but still people go and buy Panadol. Okay, although now we have our local brand Ufamol, but still the market share, there is still market share for Panadol. Of course, Ufamol have taken its place also, but it doesn't wipe out Panadol. Okay, so as just now I was during the introduction, I was told that there is 100 young something just now. What is it, Dr. Sharul? Who is it? Eman, Mr. Eman? Okay,
Manzul.
all of you talented young people, because I'm not young, you all are still very, very young. So make use of your time, ensure that you have all the good skill that is needed, okay, to build. Because when you enter, similarly, when you leave university or you leave the education sector, those what you learn in university is actually to prepare you, to prep you. If you are going to become a good computer scientist, a good biotechnologist, or a good and in general a good inventor, a good innovator, okay, no matter what sector you are, no matter what background you are, okay, you need to have a good strategy in order for you to be in the company, because frankly speaking, Malaysia is now still manufacturing country. We have all the manufacturers here in Malaysia, but we don't really have a good high level innovation or technology being created here in Malaysia. Of course, we have small innovation. We have local SMEs that are good, that strive from the beginning, from zero to become a millionaire and rely on IP. Okay, maybe I later will share a few examples. But you students, you young people, you VIPs, if you have a good knowledge, and what SME want is actually someone who can help them, the human capital that can help them grow to the next step. Okay, and if you know how to look for gaps, look for how to solve problems, you are going to be useful for the business entity. Okay, I think I stop here first.
Thank you very much, Puan Nurunoha, for such interesting topic. I like it, and I like the time you mentioned about creation and has to protect the creation. The liquid paper created by one of the actors, because the during that time the economy was not. I mean the bidang perfilman was not good. So what they have, she has to work as a typist. You remember when I was in university, we use typewriter, and in order to delete, we have to go and get a liquid paper and liquidate. I don't think they have this kind of experience anak-anak sekarang ni. So it was quite difficult for us because we tak boleh tekan backspace. So now liquid paper has been reinvented. I think it has been patented, and we now using this kind of thing, which is faster and less messy, and it's
Yes,
interesting too. So
always, yes.
yeah, so that's why we need to protect our new innovation, like what Dr. Rahmat had mentioned before, and Mr. Robes Young. Why we need to be here today? Because it's important to understand the category of IP, and also how does it being carried out from the industry point of view, like Puan Nurunoha has experience and working on that. Because in the classroom, we were not exposed about the real situation outside that we need to understand IP. So please stay put with us, and I would like to invite Dr. Shahrul to further discuss about IP from the from the education angle of view of angle. Okay, please, Dr. Shahrul. Thank you.
Thank you so much, Madam Haniza. Okay, because I'm a lecturer, so I will show again my slide as well. Okay, so intellectual property in education sector. So just like I said before, we'll explain more about patent, trademarks, and copyright. I will stress more about copyrights. Okay, so however, I will explain about patent and trademarks as well. So let's see. Let's go about patent. Okay. So what is patent? Just like what Puan Nurunoha explained just now, it's important, right? Because the new inventive step also industrially applicable. these three criteria is very important in patent application, because these three criteria mentioned in the Patent Act 1983. So generally there's two type of patent. There's a process patent and also a product patent. So product patent, just like the things that you see on the right side here, this do you know what is this? What is this? Anyone knows about this invention? Anyone? Maybe you can type on in the chat room. No?
There's an answer from our audience. Phone, smartphone,
Smartphone,
from
right?
Muhammad Izlan.
Yeah,
Yeah.
smartphone from UNICEF, right? Yeah, it's a smartphone. It's a smartphone from Apple. So as you can see here, there's an Apple incorporated here, the company. So the inventor is Steve Jobs. Yeah, as you can see here. So these are actually the product itself. So this is one we call as a product patent. Meanwhile, process is another type of patent that I don't have any kind of example here, but it's actually one of other type of patents viable. Those patents is actually you need to register with MyIPO. MyIPO, just like I said before, is a administration body in Malaysia. So the protection that you get is 20 years from the date of the filing. Okay. So the utility innovation, what is the utility innovation? Utility innovation is slightly, I can say, reduce a bit from the patent. So if you can't get patent, you can get a UI, utility innovation as well. So it's a minor invention without inventive step. Okay, that's what we call a utility innovation. This also need to be filing to the MyIPO. Okay. So the Patent Act mentioned the patentable invention is an invention is patentable if it is new, involve an inventive step, and it is industrially applicable. It is a solution to a specific technical problem. This one is actually mentioned in the Patent Act itself. So as I said before, utility innovation is a minor invention without the inventive step. So in case you don't have you cannot get the patent, you can file for the UI. Okay, so that's the two type of patents that are viable under the Patent Act. So the important elements actually in patent, it must be a technical problem solved. So you have to solve some technical problem. Okay, it must be a solution, something that they solve the problem itself. So from the perspective of technology, I mean technically how it solve it. So that then you will get patent. Okay, so the patentable invention also is actually created and not disclosed to the public before the priority or the filing date, just like Puan Nohan mentioned just now. If the invention has been disclosed, the time for filing is actually 12 months. 12 months. Let's say you just accidentally disclose the invention to the public, you may register it within 12 months. There's a gross period within it for the registration. But there's also non-patentable invention. That not all of the invention can be patented. Okay, so there's something like discovery. If you, let's say you found something like a material, or metal, a new metal on Earth, right? You try to patent it. You just discover it in your backyard. So you cannot patent the metal itself. Okay, because this is a discovery. You just accidentally find the metal. So it's not patentable. Okay, animals, plants, mathematical theory, business method also is not patentable. Okay, it's not patentable. Method of treating humans, animals also is not patentable. Okay, so those are actually some things that actually you cannot patent, because if everybody say about innovation, invention. Yeah, of course. There's an area where you can file the IP itself. Not only through patent, perhaps you may register it under the IP type as well. For example, copyright or something like that. Okay. So how to get a patent? First of all, you have to identify the key invention itself. And then you will need to draft the patent and filing the patent to the MyIPO. And then you will get patent granted. I will say that this is just from the general perspective. Technically, Puan Nurul Nuha is no better, okay? Because those all this is actually can be done by the patent agent itself, just like Puan Nurul Nuha, okay? That's why the price of the patent itself is quite expensive. For example, for you guys to register a single patent in Malaysia, it will cost you more than 8,000, 9,000 and above. Okay, so meanwhile, you as inventor have to work together with the patent agent in this area, because you have to explain the patent agent what is your invention itself. You have to draft it into a single in a piece of papers. Okay, let's see, for example, here. Do you know what is this? The type of the patent file name is a method and means for creating anti-gravity illusion. Do anyone know about this kind of invention? The keywords is a celebrity. It's from the celebrity.
Celebrity can become an inventor, you see?
Yeah.
Celebrity become an inventor because he faced problem
MJ.
performance.
Yeah. Most of you answer the correct question, okay? This is MJ. So it's actually Michael Jackson, MJ. You can search the patent file in the internet, because you can see here method and means for creating anti-gravity illusion. So the name is actually Michael Jackson, Jackson. Okay. So these are the things that you need to draft. This is what we call patent draft. Okay, patent draft. You have to file it and submit the application to the MyIPO. So as I said before, who will do it for you is actually the patent agent. They are the subject matter expert. Okay, they will work with you together as an inventor, the inventor. So you will draft the patent properly and try to file it to the MyIPO. Okay, so these are actually the patent. Let's see about trademarks. Okay, so trademarks, any words, logos, pictures, names, letters, numbers, or combination of it can become a trademark as long as it will involve with any commerce process. Okay, so as you can see, there's a lot of logos here on the right side. There's this, for example, Google is actually a names. Okay, there's also a combination between names and logos. I think names and logos. IKEA, there's a yellow circle here. Combination. Amazon also, there's a smiley face. There's a smiley face here. Amazon, Microsoft also, they have a combination between names and also logos there. So it's actually this is what we call a trademarks. Okay, so usually the symbol that we use is actually this one, the R in the circle, TM, and also SM. SM, the one that we call service mark. Okay, TM is actually not registered. Not registered. It's an option actually, because in trademarks world, there's also marks that can be used without or no need for registration with the registrar office. Okay, so if you register a trademark, then you will get granted by the MyIPO. You will put the R logo at the end of the marks. Okay, so that means your logos or your marks have been registered. That it has been registered. So these are the differences, okay, between the one in the circle, TM, and also SM. Okay, so the concept is quite easy. Whoever register first will get it first. Okay, so who's the one file it, and will get it. Okay, so probably in the business world, in the business that you use for branding, for celebrities also they use trademarks as a branding for themselves. Okay, provision of registration. So deceptive or misleading trademarks is also prohibited, yeah, from registration. Scandalous or offensive also prohibited from the trademarks registration. Harmful to national interest or security also prohibited from the registration. Who's are the one control this kind of the registration? MyIPO. In Malaysia, we can call it MyIPO. MyIPO will decide whether the marks will be accepted in our country. Okay, trademarks function, there's an origin function, selection function. This one actually is actually more towards the marks function. So it depends. It depends on the intention of filing the trademarks. Okay, the importance of the trademarks, you will get an exclusive right, and it will valid evidence according to the law. If someone try to use it without your permission, you can sue him. You can sue them. Okay, so that's the important things about trademarks. Okay, let's see about this marks. DSV. Anyone realize this kind of logo here? DSV. Anyone?
From the sound of it, DSV. Does it click on anything? Pandai ya, doktor.
One of my friends work with this company actually in
Really?
KLIA. Yeah. So Datuk Sri Vida, yeah, correct. Look identical, right? Very look identical. I have problem with my mouse actually. Try to click. Okay. Does it look similar? Identical?
Looks alike.
Looks alike, right?
Yeah, but I believe it's for different sector, different class.
Yeah, different class. Oops. So both register under different categories, or different class. That's why DSV still can submit their trademark registration to the MyIPO, okay, and be accepted by the MyIPO. Okay, so that's all about trademarks. Let's go to the copyright. So this is the most of closely related to us, someone from the education sector. Okay, copyright is an exclusive right that protects any form of works, writing, singing, or something. So those actually protected under copyright. From the computer science perspective, all the programming codes is also fall under copyright. Okay, fall under copyright. So copyright is actually generally is no need to register. However, MyIPO provide some platform that we call a voluntary registration to the MyIPO in order to manage any kind of disputes about copyright. So we can register copyright with MyIPO, and we get a certificate or something for MyIPO in order, and that will actually be a proof, act as a proof the copyright is belong to us. But generally, copyright no need to register, okay? Because the protection begins after publish. Let's say I try to create a new song, and then I sing it in YouTube. Okay, sing it in YouTube, and then automatically the copyright of the song it belong to me begins from the date I publish it in the YouTube. Okay, so that is a copyright. Okay? The duration is a bit different between the type of the copyright. Literary, musical, or artistic work usually is around 50 years plus the age of the author. Means that if someone live for more than 60 years, let's say 65 years, so the protection for their songs or the artistic work created by the author, it will the duration is after 50 years after the death of the author itself. Okay, so that what it means. When you are the broadcast drama, film, movies, sound recording, entitled for 50 years only. So let's say P. Ramlee, Allahyarham Tan Sri P. Ramlee. So meninggal dunia bila? 1973, right? 1973. So let's say lagu-lagu dia macam mana? Can we sing the song in any kind of event, public event or something? Is it we can sing P. Ramlee's song in the public event? Any answer? Can? Kena tolak tu. 2021 kan?
Boleh,
Kan?
dia orang jawab boleh.
2021
Ya,
deduct to 1973. Dah cukup ke 50 tahun?
20 cukup. I was in standard 1, 7 years old. No, one more year. One more year. I was in standard 1 kan. So
So
I'm 56 to minus 7. Belum. One more year to go.
but in my calculation,
Is it?
only
I think so.
48 years, right?
Yeah,
Baru
about
48.
that lah. By
So
next year,
belum
56,
belum 50 tahun
57.
lagi.
Another
so
2 years lah to go.
So kita tak boleh, we cannot simply take the song and sing it in the public. Okay, we have to request for consent. Request consent in order to sing the song. Kepada siapa? So mungkin dekat dia punya waris, waris or something. Inilah. So that's how it works. How about if I open a restaurant and then I put a TV over there and then I try to I play a movie, Pendekar Bujang Lapuk, 1959. Is it eligible for me? Is it I'm okay with that? Boleh ya? Can yeah, true, because the protection is only 50 years. 50 years. So theoretically boleh lah. Theoretically it can be done. But practically you have to ask Puan Runoha later, okay? So that's actually it works. So the copyright, the eligible works, or literary works, musical works, artistic works, literary works, all everything is related to the publication, I guess. The books, programming codes also fall under here, if I'm not mistaken. Okay, so these are the list of eligible works. Meanwhile, the unprotected works, all the ideas, procedures, methods, or operational or mathematical concept is unprotected. It's unprotected. Just like I said before, all the ideas is not protected. Okay, idea, semua orang ada idea kan, so it's not protected. The quality and purpose of the work are not taken into the account. We will not measure the quality of the work. As long as being published, it belong to the author, belong to the creator. Okay, they become the owner. That's what it means. Okay, so copyright about music, beginning in section 27A Copyright Act 1987. There's licensing bodies actually, licensing bodies in Malaysia that allow to handle all the copyrights in related to the music. Okay, something like this related to the lyrics, composer, MACP will handle it. Okay, we will handle it. Meanwhile, all the recording company will be handled by the PPM. Or singer, musician will handled by the RPM. Meanwhile, in the film industry will handled by the MPLC. So copyright in education sector, the most closely related, the things that we are published in the books, right? In the books, especially the researcher, the lecturer, and the student itself. student usually in the final year will publish what called a laporan technical, right? It's a technical report for the FYP. That is actually fall under copyright also. So the things that are generated by the researcher, the lecturer, including the e-learning material, something is also fall under copyright. Okay, so for the quiz student, perhaps maybe you guys familiar with this kind of declaration form, right? That will be put in your thesis or the technical report, especially for the FYP. So these are actually the declaration that you are a part of the quiz and a part of the institution, and all the material, all the tangible assets actually belong to the quiz. Because why? Because you are studying in quiz. Okay. Same goes to the UNICEF. Same goes to other institution as well. Okay. So as long as you engage or related to the institution, all your tacit knowledge that translate to the explicit knowledge, such as the FYP project or something, actually belongs to the institution, because you have been guided by the lecturer. Okay, guide the lecturer. Some of you use the facility provided by the institution as well. That's why all the IPs actually belong to the institution. Okay, but no worries. If you think about the monetizing all the things, right? So it's a different matter. Perhaps Puan Nurunuha will explain about it. Okay. So who's are the keeper in the university? The library. Okay, the library. The library. So all the IP material will be kept in the library. Okay. So these are one of the example. My student. Okay. Muhammad Adri. So what actually he did in the FYP project is something related to the IoT, Internet of Things. What he did actually, I tried to create something that can what you call, make things easier to the civil workers. Okay, because for example, there's a construction in the road, on the road. Okay, on the road. Then the road need to be closed one side here, for example, right? So there will be one guy standing there and try to handle all the traffics, give the traffics over here to go pass through the traffics. Okay, so what he did is actually try to put a sensor that will detect any cars or any vehicles stopped by here, blocked by the construction. And then after a while, after I think around 5 to 10 seconds, the light, there's a traffic light over there, the mobile traffic light, what we call the mobile traffic light, they will change from red to the green color and allow the vehicle over here to move and pass through the construction area. Okay. So this is how he control the traffic. The products is called mobile traffic light. Yeah, mobile traffic light. Okay. So these are actually things that he did in the FYP. Okay. So all the data will transmit to the cloud. Okay, for further investigation or further analysis. Let's say the in one day, probably on weekend, the number of vehicles detected by the sensor is around 1,000 or maybe 10,000. Then perhaps we can increase the time for the lights to turn on. Okay, so that's a thing that he did actually during the FYP. So these are the actual product developed. They only use Arduino. Okay, Arduino and a few sensors for his project. Okay, so this one is actually registered for the IP, register with the MIBO. Okay, so what's your idea? What's your idea? Yeah? So you as a student, perhaps can come out with a good idea and try to translate in your FYP project. Regardless what kind of a project you want to do. So you may come out with a good idea and try to file your IP with your institution. Try to make Malaysia better with your idea. Okay, I give you a few other examples in industry because I have 13 years experience in industry, right? So there's one company try to produce something what I call user experience. The user type is actually the reader, the very what you call it? It's a reader, a book reader. Okay? Try to increase the experience of the book reader. So what he did is actually he put an RFID at the in the books. Okay, in some area in the books. For example, if you read a books of Star Wars story, right? So there's an area where you can there's an area where the fighting area using the lightsaber, right? The lightsaber. So probably in the page 60, 70, something like that, they put a RFID tag over there, and then once the reader flip the book, the RFID reader will trigger the RFID tag will trigger the RFID reader beside him or she, and then the rooms will fill out with the sound of the lightsaber, okay, or something like that. So they increase the user experience while reading the books. Okay, so those are actually come from the simple idea. Try to increase user experience from the book reader. Okay, but how you implement it, it depends on your technical know-how. Okay, you as a student perhaps have learned from your institution, can come out a very good technical know-how lah. So that's actually an example of the good idea that translate to the registered copyright idea. And if I'm not mistaken, the company only filed for copyright registration, and then the one of the big company, Creative Labs, if I'm not mistaken, the company bought his company. He bought his company and bought the technology itself. Yeah? So the monetizing will come later. Yeah, the will comes later. So before you file any kind of IP, it will begin from the idea. So make sure you guys have a very good idea before you do all the final year project. That's all from me. I think I can pass back to the Madam Haniza.
Well, Dr. Charul, it was so interesting. I just catch up the last part of that just now. A book with an effect, sound effect, so that when we read the book, we can have the sound. I'm not a fan of Star Wars because I don't like science fiction so much. But I read a lot of Miss and Boone romance, Barbara Cartland book. I think Puan Nurun Dohan knows about that. So I don't think it's applicable to that kind of storybook. I don't know, but I think not applicable to the romance book. But I did read a lot because I need to improve my English writing, all the vocabs, and it helps me a lot. But that was a good idea. And one thing about what Dr. Shara said just now is about copyright to the educator. And actually, copyright has eligible works that you can protect and also unprotected works and things like the Michael Jackson shoe 45 degree. I just knew about that. Thank you for sharing. And to answer how to get our product protected and other things, I would like Puan Nurul Nuha to explain to us. It's getting interesting and more interesting. I like this. Thank you very much. Puan Nurul Nuha, back to you. I think you have to unmute. Please unmute. We can't hear you. Your microphone.
Okay, sorry for the glitch. Just now, Dr. Shahrul shared about the copyrights, and one example was provided, and there is also improvements on the normal usual reading, where you read written words and sentences, but now together with reading, you can hear some sounds. Okay, those are some form of improvements. And then Puan Haniza just now mentioned about how to protect copyrights. Copyright, of course, as mentioned by Dr. Shahrul just now, there is no registration, there is no compulsory registration. However, in 2012, there is a Copyright Amendment Act, which allow author to file for voluntary notification. And since then, the court has take a stance that if you do not take action, if you do not, as the author, you do not take the initiative to file, means that you are not serious in protecting your copyright. So it's always best. It is always best to, if you feel that you want to monetize it further, it is always best to submit voluntarily to my IPO. And the fees are actually not so expensive. It's very minimal. It's for mass adoption. It's just that you have to, if you file it on your own, you have to make sure you prepare a proper oath, and you ensure that you are you fill the form correctly. Okay. So continuing from the earlier slides, Dr. did mention about monetizing IPs or intangible assets. Okay, just now I give an example of pharmaceutical product where the lifetime of pharmaceutical products is always longer than the 20 years period provided by patent. Okay, that's why we can still see paracetamol and those the brands that succeed the patent lifetime, the legal life have ended, but the brand name is still there and the product is still there. However, some invention or some innovations, it does not last long. Some technology it become obsolete earlier compared to the legal life. Okay, for example, some product, the invention, especially those that relates to IT development, there's always new things coming up, and there is no new improvement. So as IP owners, or as businesses who owns IP, you always have to rigorously look into your portfolio. Your portfolio can be patent, design, copyright, and all those IP categories, but some of the portfolio might have shorter technology lifetime. Okay, when it has shorter technology lifetime, you may not want to renew the patent protection. Okay, you stop it at certain time. For example, the duration is 20 years. If the technology lifetime is shorter, then you may review it from time to time. It is always best to have good business IP culture, and it is always best to, if you just innovate, it is always best to record ownership and continue to do internal audit. Similarly to university has also practiced this. Some, frankly speaking, in Malaysia, the IP generators is still universities. Universities are the top filers in patent. Unlike in other countries, unlike in Germany, unlike in Korea, unlike in Japan, in US, those countries, the top filers are actually the companies, the MNCs. But in Malaysia, the IP generators and IP filers is actually come from the universities. Okay, we want, and I urge those VIPs in future to help SMEs to create and to file, to change the numbers, the percentage, so that more and more SMEs, more and more companies are filing patent protection in Malaysia. Because all of you are actually students from FSTM, and all of you are good in IT literate and all that. All this information is available on the net. You may search at MyPo website, you may search Google patent, you may search USPTO, you may look at examples of patent documents. And frankly speaking, this 2 hours period is not enough if we would talk to touch all aspects of IP, and I'm here to share you the most important key element. Okay, so among others, in intangible aspect, IP innovation is not solely used without application together with the customer. For example, trade secret just now, if you have a good customer list, if you have a good fan base, those are actually your asset, your intangible asset, where you have new product, you introduce to them first, okay? So, and then you only allow it to mass market. So these are actually strategy where businesses can make use in order to be sustained in the very challenging world nowadays. To give example, a local example, I share with you Siti Khadijah. Siti Khadijah is very close to us. It's about 1 kilometer, 2 kilometer away. Starting in Section 9, Bandar Baru Bangi, is a housewife helping husband to increase income. At the beginning, she requests from her husband $10,000, 10,000 ringgit, in order to start creating and to start developing new product and producing few samples. Okay, since 2009 until today, it's already been 13 years, and she has grown. The company has grown from only having a small, renting a small office in Bandar Baru Bangi, and now having its own manufacturing facility in Selaman. And they are also now aiming to go for public offering, initial public offering sometime maybe next year. Okay, so this is actually how one business can actually grow and be impactful. This kind of invention that Siti Khadijah Puan Fazila Endah created. Of course, it is not patentable. It's not. She didn't go for a patent at that time. She did register for her mark. She did register for her design. She knows that at the very beginning, when she's still a sole person doing this innovative activities, she knows that she already filed a patent in design in Malaysia. She straight away filed a design in Indonesia within the span of period where you can still claim the priority. But at that time, she did not register Siti Khadijah mark in Indonesia. Okay, so she registered Siti Khadijah mark in Malaysia. So when her business grew and she embarked into Jakarta, into Indonesia, in Java Island, Jakarta alone, the population is actually almost the same as the whole Malaysia. Okay, so the market there is actually very huge. And what happened was, when she entered into the Indonesian market, Jakarta particularly, there is an artist who is actually already filed a trademark Siti Khadijah in Indonesia for the same class. Okay, so what happened was, we have to negotiate, we have to buy back that mark in order for us to be able to enter into the pasar-pasar. Di sana dipanggil, over there they have a lot of pasar-pasar, and Siti Khadijah is actually in Faris Banjava. It's a very huge mall in Indonesia, and Mangga and all that in Jakarta. And it is, although the market share is still small, but if you look at the number of people in Jakarta is sufficient. And when you start a business, you not only look into Malaysia, you want to go cross-border. You want to go cross-border. You want to be impactful. You want to aim to go cross-border. And IP, most of IP categories just now, patent, trademark, design, are actually territorial in nature. So if you want to embark or you want to enter into other markets, you have to file for protection in other countries. Okay. So what I did if Siti Khadijah is actually we consolidate all the IPs that belongs to Siti Puan Fazila into a company, and now when they want to move into getting ready for public offering, you have to ensure that all your IPs are actually intact. And this Siti Khadijah, they are very serious. They did not did not just stay put or just let people copy their product. They do take action. They stop people at border. Okay, they take legal action. They sue certain companies that copy their products. Okay, so those are the things that you have to, when you are into business, you have to protect your business. You have to ensure your business sustain in the right manner. So meaning you already take all the necessary steps in order to ensure that you able to use IP as a tool to enhance your business. Okay. And nature of IP is transferable. Just now I give you example when there's one artist in Indonesia file for Siti Khadijah mark. So we go there and we negotiate. Of course there is an agreement. There is some money transacted. Of course, if Puan Fazila had filed earlier, there's no need for this cost. Okay, but these are action that you have to take. Okay, when you are in this, you have to do and you have to take steps to ensure that you cover everything. Okay, so IP is transferable, where similarly patent, trademark, design, you can assign it to a new entity. Okay, you can structure it. And when you grow, you can ensure you can get involved into mergers, you can get involved into acquisitions. Okay, for example, if you know Uber and Grab is Malaysian based, long time ago moved to Singapore and now already listed in Nasdaq. Backdoor, I'm not sure, but it is already listed in Nasdaq. So Grab, although the technology, yes, it is a student from FTSM, it is a platform technology, but they have very good branding capability, and that's why they are everywhere. And Uber, although they are the first mover in this sector, but they eventually in Southeast Asia, they have to back out. So what happened was they transfer all, they offer to Grab, and Grab purchase all their business in Southeast Asia, but Uber is still there in other markets. Only in Malaysia, they merge. And what happened when there is no Uber? Grab has all the monopoly in Malaysia. Yes, now we have other other brands coming up for the same sector. Okay, but when you have when you are already in the market and you do good marketing, you have good branding, you have your brand protected, and user will always remember you. Okay, so remember, IP is transferable. It is a tool. Similarly to tangible asset, you can move it. Okay, you can move it once you work on it. IP, invention, brand, copyright, if you do not work on it, it doesn't give you value. You have to work on it. You have to work on it means put an effort, advertise it, acclaim it, sell it, offer for sale. If you do not do that, it doesn't has value. It has only paper. It has only paper value. It has only paper protection. But you do not test it. You do not push it forward. No value there. Okay, you have to ensure that all effort is being used to market it, and all effort is being used to ensure that all the aspect of IP is being covered. Okay, and IP is actually, why people look at IP is actually to manage your risk. Okay, to manage risk when you enter into market. If Siti Khadijah didn't purchase or didn't acquire that brand in Indonesia, there's a risk for them to get their products taken out from the shelf by their enforcement officer. Okay, so they have to take that measures. Okay, so It is context sensitive, depend on background users, context that determines relevance of IP to business. So you have to look into each businesses have different the importance of IP in each business are different depending on what are actually your core things. Either it is a high-tech technology or it's only copyright and design. So how you apply this is varies companies to companies. Okay, so it is perishable, as I mentioned just now. Some IP is you don't use the technology now. For example, if you look at the coal country furnace ataupun kalau di Malaysia dapur kayu, we don't really use it now because we have the gas stove. Okay, but in certain condition we may still use dapur kayu. Okay, so it is perishable. Some technology have shorter technology life, some technology have longer technology life. Okay, particularly in pharma or bio based, or those are technology that have longer life. Okay, that is why if you remember, if you read the newspaper, if you read the news on the if you search Google, you will see that long time ago there is an initiative by many countries to come in to offer TPPA. Why IP is one of the elements of the Trans-Pacific negotiation is actually because some countries want to extend the term of protection for patent. Okay. Similarly, in other countries, in Malaysia, we still maintain 50 years for copyright, but in other countries, for example, in UK and US, the term of protection for copyright is already extended to 70 years. Why? Because the income from the creative industry also boosts the revenue of the country. Okay, people in US businesses export their movies. Korean businesses export their movies and drama, and all our youngsters are now always in front of the PC or in front of the phone watching oppa. So they are actually exporting their work. Okay, those are actually IPs, copyright. Those are actually streaming back income to the country. Okay, of course, IP is risky. It's used to manage risk, and it is also risky affair because you have to ensure that your invention is actually new. You have to ensure that nobody is actually doing that, but you can't be really sure at that point. Okay, once you enter into registration, once you enter into the market, sometime somebody will come and say, I already patent this, I already invent this long time ago, I'm the first user of this. Those are the example of the risk. Okay, and of course when you create, you are going to spend time, spend money to pay attorney, spend a lot of money. Those are actually, please consider that as investment. Please consider that as investment. Once you already file, make sure you work on your invention and ensure that you get back the return. Okay. So useful for excluding. Of course, the nature of patent is actually to fence off. It is actually to build what do you call fences, so that it prevent others from entering into your domain, your market, your what you have created. However, as I explained earlier, patent and some other IPs are territorial in nature. If let's say you file a patent in US, but you did not file a patent in Malaysia, and somehow Dr. Rahmat or Dr. Sharul goes to US and see this product is useful, and then you come back here, you go and check the patent database in Malaysia, you see, oh, this company does not extend the patent protection in Malaysia. Okay, so you are free to operate the invention in Malaysia. Okay, so it is non-rivalries in consumption. What does this mean is that one IP product, one patent, for example, can be used in many, can generate many income stream. For example, if you use if the inventor created a composition for treatment of some disease, for example, and the disease is actually inhuman and also applicable for animals, for example. So you can have a license that for different category. One is for human, one is for animals. So you have revenue stream from different different category of business. Okay, so that is one example. Another example, if you talk about copyright, you may have one book, for example, J.K. Rowling's. If one Haniza tak suka, doesn't like sci-fi, this is not, I'm not sure that this is sci-fi, but it is fiction. Okay, J.K. Rowling is fiction. All the Harry Potter series, you see, one time she has been rejected. She authored a book, and now she has she first market her books, okay, and that is one revenue stream. And then eventually she together with a producer create a movie, that is another income stream. Okay, and then you can have a merchandising, where those are another income stream. If we talk about music, for example, song, you can have it being used as a ringtone, you can have it used, you perform it, you get income from performance, or you can license it to movies, as a soundtrack. You can use it in many ways without diminishing its worth. Okay, all those activity, all those when you work your invention, or when you work with your creation, all those contribute back to the value of the IP. Okay. We have time. Okay, we have only 30 minutes, and these are all examples. Okay. You can, for now I'm talking about brands. If you have a good brands, for example, Siti Khadijah and other brands, or Siti Khadijah and no brands, or Tesco brand and Heinz brand, you can premiumly price your product. Okay, for example, Tesco tomato paste with Heinz tomato paste. Of course, there is a difference. Those are premium pricing. Okay. Okay, ownership can attract. Okay, IP ownership of course can attract potential partners. Okay, to give you one example, yes, I am a Sinovac recipient, 2 dose Sinovac recipient, not yet the booster dose, but I'm going to get the booster dose of Pfizer. Okay, Pfizer booster dose. But you remember, Pfizer did not really invent that vaccine. Okay, the vaccine was actually invented by a Turkish couple who are residing in Germany, and the company is actually BioNT. That's why you call Pfizer BioNT. Okay, Pfizer BioNT. But BioNT owns all its patent that relates to the vaccine, and of course there is some element of cross licensing with others. Okay, because it's based on RNA. But this BioNT, because of the instantness of the case, Pfizer just together with Pfizer and BioNT negotiated, and they go to the market with a synergy. Pfizer did not acquire BioNT. BioNT go together with Pfizer in the market, and now you refer to the vaccine as Pfizer BioNT. They still own Pfizer, BioNT still own their patents. Okay. All those things you can search in the internet. I'm just highlighting it here. All those information is there. Okay. Okay, you can use in Malaysia now. There's initiative to use IP as collaterals, and for example, KRU Group, they meet with MDV, and they pledge their copyrights to get some loan, to get some very good interest loan. In those initiatives, actually when in the RMK 11, if I'm not wrong. Okay. Of course, Malaysia also have provided tax incentive for IP creators, okay, and IP owners, okay. And of course, you can, in order for you to ensure that there is a more value change, you may use this business model, which we refer to as licensing. in whether just now I mentioned about licensing in human sector, licensing in animal sector, licensing for merchandising, licensing, and to give you one simple example, for example, Pepsi Cola, the company owns only the brand. They don't really go to Malaysia and put up a manufacturing facility. No, they license it to a local company manufacture. They only check the quality. As long as it meets their quality, they put the brand there. Trademark owned by PepsiCo, but manufactured by who in Malaysia? Okay, so the owner of the IP, the owner of the brand, cut down the overhead. You don't have to worry about the overhead. Let the company, the licensee worries about that. Okay. Okay, so IP is a performance driver, though all these companies, international companies, are all driven by IP. And here is an example in Malaysia. We have Fasana, Bloomdis, iFlix, Bungkusit, and my client and international NSTY, House Boom, the Boom Beverage. They do not only once you are a creator, once you create brands, once you will have that intention. You will start creating and creating. You create one, you create more and more and more. Okay, because you want to ensure that the S-curve of your inventing capacity and also in your business growth is actually maintained. Okay, and Aerodyne is actually service-based and also brand-based. Okay, so I think that's about it.
Okay, thank you very much, Puan Muha. There's a lot of examples had been given to us. And I also heard something, whether it's true or not, that Nilofa has once, her product has been copied by one company in Vietnam, if I'm not mistaken, the scarf. And she went to take action against the company, but I'm not sure whether she had patented her product. And one more thing about Siti Khadijah, I'm very interested. I know that from creating the value through IP has helped increase the because it becomes premium product, right? So it was quite expensive for ordinary people to purchase, but there are also companies that had copied the pattern, the design before Puan Fazila, if I'm not mistaken, patented the design. There's a lot in the market. I always look at the ladies who wear Siti Khadijah in masjid, and dia jadi saya tak sangat khusyuk lah masa semayang tarawih that year when Siti Khadijah was gedebum, you know. I tengok yang mana satu perempuan-perempuan ni pakai bel. Oh, banyak duit lah tu. But I got 3 hadiah daripada my friends because dia tahu saya sangat suka Siti Khadijah, very comfortable. Okay, I would like to bring up this question. Mr. Robert Young is with us. The question is, can we use someone trademark if they are still under TM? So that's one question. Let me see, is there any more question from the audience? Okay, another question is on the chat. If I create a product or invention in execution of a task of an employment contract, will the product or invention be mine, or will it be the employer? That one is from Encik Amir Rizwan, Unicel. So I think the first question, that can we use someone trademark if there is still under TM? Puan Nurul Nuha may answer that. And I don't know about the second question. Let us decide after this. Okay,
I may take Mr. Robert's question just now. The differences between TM sign, under TM, and R in a circle sign is that, as explained by Dr. Sharul, TM sign is being placed or being put at the side of the mark for the purpose of, if the business owner would like to use that as a mark, the business owner may put that TM sign. And of course, it is if the business owner not yet filed for a trademark, then it is a unregistered mark. But if because trademark, the term trade refers to use for trade. You have to use it for trade. If you intend to use the mark for trade, by itself, it is a trademark. However, trademark, not all words or can be registered as or fulfill the registrability criteria of obtaining a registered mark. Okay, so some may require some form of use prior to it's able to being registered, because among the criteria of being a registered mark is that it become distinctive. It is distinctive in the eye of the consumer. If it is not distinctive in the eye of the consumer, then it is not a mark. If it doesn't relate you to the product, then it doesn't create. It is not a trademark if it doesn't relates you as the business that offer the product. If it doesn't relate you, then it is not a trademark. Okay, so once you if let's say you file for a trademark and the trademark gets registered, you want to use R in a circle, or you don't want to use R in a circle, or you want to use just TM there, no problem. Because it is already registered, it's already being protected by the law, whether you use it with or without, whether you put an indication of TM or whether you put an indication of R, or whether you not put both. Okay, it is already registered. What is needed is just the certificate. If you want to enforce it, bring the certificate, show isi borang dekat KPDN HP enforcement officer website, go do the surveillance and submit the report. If you want to do the enforcement, if you want to use a criminal enforcement officer, yeah, or if you want to bring to court, bring the cert, and it's easy. If you are unregistered mark without the cert, you have to prove goodwill. To prove goodwill, you need to use it for certain time. Okay, to give you example, booking.com, owned by a company in Netherlands, if I'm not wrong, Booking BV, if I'm not wrong. That company, the word booking is does not fulfill registrability criteria because it's very direct reference. Okay, but booking.com is finally being registered in the US after 9 years because of use of the mark in the specific stylized form, not the word booking itself, not the word booking as in the dictionary. Okay, I hope that explains.
Okay, thank you very much, Puan Nuha. Okay, the second question goes to Dr. Sharul. The question is there in the chat box. So please, Dr. Sharul.
Thank you so much, Madam Haniza. Thank you so much for the questions from the Amir Rizwan. Okay, let's say the product or invention is actually created by you during working with a certain company or something like that, right? So the author of the invention is actually belongs to the owner, belongs to the creator. But let's say you are working with a company and then you use the facility from the company, subject to the the answer is very subject to the policy of the company. So let's say the company said before you sign up with the company, probably you sign any additional document, not only for the employment letter, right? So you sign another document such as the IP company, NDA, IP agreement, NDA, non-disclosure agreement, something like that. Additional document that you need to sign up with the company. So it depends on the agreement itself. Some company put it in the agreement that probably the ratio is actually between the employee and the employer is stated in the agreement itself. perhaps 70-30, 80-20 or something like that. So it depends on the things that any kind of agreement between the employee and the employer. So this actually happen, most of this actually happen in the creative industry, I believe, because the industry creative is they always produce something, what you call the copyrights, the creative results from them, such as design, movies, songs, something like that. Right? So if let's say you are being paid in order to produce those kind of the IPs, so logically is actually the most of the IPs belong to the company. For example, I give you an example. What happened to one of the cartoonists, Ujang, right? Ujang. So what happened to him actually during what's actually the company? Mall, actually mall company, right? What no?
MOY.
Moy. Yes, Moy. So while working with Moy, right? He already signed an agreement with the Moy, with his company. The company is working actually. So most of all the creative content produced by him is actually literally belongs to the company. So nothing else he can do after fighting for so many years in the courts, right? I believe, because most of the IPs actually belong to the company. If I'm not mistaken, maybe Puan Noha can edit more about it. So that's actually my answer. It depends on the contract, the agreement between the employer and the also employee. Okay.
Thank you, Dr. Sharul. Let's just wrap up a part of that. It's actually depending on the agreement that both parties has agreed upon. So the percentage, like Ujang case, I remember he was one. He is a very very talented cartoonist. He has produced a lot of cartoon for Gila Gila. I was one of the fan too. So maybe Puan Noha, would you have anything to add up to what Dr. Sharul had explained just now?
Just the basic thing in IP ownership is that, number one, author are always the first owner. It cannot you cannot deny that. Author, inventor are always the first owner. However, the ownership may be transferred because of assignment or agreement or commission work. If let's say there is anything written, or if you work under employment, if where you are requested to do certain to create certain things, to publish certain things, so the rights are being transferred to the one who commissioned the work, or the one who are employing you, or the company that purchased that particular IP. Okay, so that is the basic thing. So the author, inventor is always the first owner, because nothing can be created without the author nor inventor. Okay, however, nowadays we have invention created by AI, but those are still debated. But things are moving, things are changing. IP is not static, so we will see. But as for the time being, author and inventor are the first owner, and then it may be transferred based on that various aspect that I've explained.
Thank you, Puan Nurunuha. There's another question from Cik Khairil Afiq. Unicel, from Unicel. How about sport? Like pattern like anak Sidik, the Sidik family has used service as service. I learn how to do as service. Dah lama tak main dah badminton, dah bersara. Can we pattern that, the as service? Because Malaysian started that. Anyone who want to answer, Dr. Sharul or Puan Nurunuha?
It's hard to answer. I mean, from my understanding is the way how anak Sidik serve the shuttle, right? So it's what you call something like swing, something like that. I'm not so sure whether it can be patented under process patent. Is it eligible for patent?
if anak sidek has created the work that is based on copyright, for example, the sidek cartoons, those are copyrighted. If the
Yes.
method of serving, it cannot be patented because it falls under unpatentable invention. However, it doesn't mean that you can't monetize it, okay, because we are talking about intangibles, okay. So you may have a way of servicing. If the way of servicing is being recorded, then you have a recorded video. That recorded video can be used for training. It depends on how you build your business model. It's all depends on how you build your business model, okay.
Thank you, Nurul Noha. Wah, dah heated up ni. There's another question from Encik Irfan Quiz. Irfan Arzik. Assalamualaikum. If you want to redevelop someone previous projects in a remastered or reboot version, what the copyright rules that we need to follow? Means that the product was there, a project was there done by someone, but reinvention. Okay, I remember Mr. Robert Young said about reinvention. Doctor or Puan Nurul Noha, this is about reinvention actually.
Reinvention or related to some videos or something, remastered.
Remastered, reboot version means that they upgrade the version, I guess.
Upgrade the
For
version.
any, upgrading the
I
version.
guess it depends on the licensing, right? It depends on the licensing from the owner of the original works. So if let's say the owners publish the works through open source or something, then it can be done. You can do it or the what you call re-event or something, or fork, something like that, fork the codes or something like that, without any issues. So that's I think from the perspective of the codes. However, from the perspective of videos or films that you like to remaster, I guess that one should follow the licensing from the author, from the owner. Is it true or not?
Puan Noha,
Okay.
would like
Okay, if as per explained by Doctor just now, if you have the consent of the owner, then it's fine. If you remember, there is one song, by the Verve. The Verve copied Rolling Stones music, if I'm not wrong. And although the song is actually famous, I don't remember the title, but the Richard Ashcroft, singer of the Verve, he has to return all the income back to Rolling Stone, okay, because no consent. So if you were to do that, you have to obtain consent
From the original author.
Yeah, there is a. If you talk about copyright is a very broad protection. If let's say if you look at photos, or for example, there is one famous photos used for campaign during the Obama session long time ago, where the original photo is actually by AP, and then somehow some writers the writers he changed the look of the photos. If you remember, Marilyn Monroe, there's a very famous photo of Marilyn Monroe, and it changed to various neon colors. There's element of originality inputted into that. Okay, so if you are talking about redeveloping, remastering, you have to really refer to the attorney in order, or you have to obtain the consent, because all these aspect of IP need to be looked into. Okay, this is the, frankly speaking, this what I'm sharing is not a legal advice. It is the basic and foundation of IP. All whatever you want to do, you have to engage the person that can help you, because all aspects need to be reassessed, to be assessed accordingly. Okay, so because it involves some people rights. Okay, if let's say the VIPs, all VIPs, if you want to know more about IP, the company itself, with the help of our special staff named Haziq, he put up videos. We have our YouTube channel. We have all the basic explanation of patent, copyright, designs, and all, and some of my presentation video. If you want to learn, those are free sharings. You can go and check our YouTube channel, inshallah.
Thank you very much, Puan Nur Noha. Okay, I would like to ask one. There's a question from Miss Najwa Tanga from Unicel. Just one more question. This is the last question before we end the session. If I create a new invention, and but I do not have the money to patent the product, what routes can I take to protect my invention?
Banyak.
Okay. Puan Nur Noha lagi. Silakan.
Puan Noha boleh jawab lah.
Thank you for your question, Najwa. Yes, I believe you have something in the pipeline. Of course, inventor, sometimes you have spent money for creating, so you don't really have money for other things, but please reach out. Ensure when you reach out, you ask people to sign non-disclosure agreement, or because without you sharing, you can't know, you won't get feedback. Okay, without you sharing, you can't get feedback. Why the government, why the IP system or patent is actually being created? Because some inventors do not want to share. Some inventors only want to use it for themselves, for their own uses, because they're afraid when they bring it out, people will take it. People will just and not appreciative of the invention and all that. So in order, of course, when you want to bring things to the market, you despite your inventive skills, you also need help. Okay, but you have to be precautious of how you disclose your information. Number one. Number two, it depends on your business model. If you really don't want to use patent, it depends on how you prepare your business model. How would you monetize it? Because there is also invention that is offered for free. For example, the Joomla, all the open source thing, all actually free for use. It is inventive, but they did not rely on patent or other IP aspect, but they rely on brands. Okay, so I give example of one Siti Khadijah. That it depends on your niat. It depends on why you want to do it. Because number one, if you really want to go big, of course it's always advisable, if it is new, inventive, and industrially applicable, it is always to seek ways and means to file for a patent. Okay, because if not, the big giants, if you remember just now I explained about Pfizer and BioNTech. If BioNTech does not patent it, macam mana dia nak negotiate dengan Pfizer, kan? If people just langgar, the big giants will just use it, you just mass market it. Okay, so that is the only thing that you can hold is actually your rights. Okay, so it's good if you are at the beginning stage. Please gather all information that you require to prepare for your journey. Okay.
All right, thank you very much to both. Boleh silakan doktor.
I guess there's a lot of funding scheme available in our country also. Under MOSTI, there's a IP grant provided by the MOSTI. Madrid also have. Last time, MDEC also offer a grant for IP registration, but of course you have to go through all the criteria and eligible to submit the application to the funder. So that's one of the way if you want to file a patent or any other IP for your use. Okay, but some university also provided internal fund. So that one also can you can utilize it by submit your application to the university. So I think that's all.
Okay, I may add a little bit. If I'm not wrong, under the RMK 11 last time, there is Dana for under 40, for Dana called Dana Pattern. You can refer to MICO, but I believe it's already habis. It's already 2021. Maybe if there is a push from the inventors to seek helps, you have to sampaikan or give this information to the one who the government, so that they can actually allocate certain amount of money to help at least small time inventors.
Yeah.
Because in other countries, for example, the developed countries, we have young inventors. And please avoid reinventing the wheel. Please refer to rujuk database, refer to database. Every country has those database. Please do that.
Okay, thank you very much. Our session has come to the end. I would like to thank you so much to both speakers for a very interesting discussion. It is a very useful knowledge and information. And I would like to thank two VVIPs that attended our session today. Thank you very much and have a nice day. Assalamualaikum warahmatullahi taala wabarakatuh. Alhamdulillah.
All the best,
Okay.
everyone.
Yeah.
Okay, bye. Have a
Bye.
nice week. Have a nice half day weekend. I'm going to go a party.
Yes,
Cucu punya
yes.
birthday. Okay, bye. Okay.